Ladies and gentlemen, we're near the end of a rather long day. Our final speaker is going to talk to you about specifically mortgagors' rights and remedies and defenses. Arthur Barat, the speaker, is a partner of Wilson and Barrett in Windsor, Ontario. He was graduated from the University of Western Ontario in 1962 and called to the bar in 1964. He has been teaching real and personal property at the University of Windsor's Faculty of Law for the past 11 years, and he is current president of the Essex Law Association. Arthur?
Thank you. I don't draw any inference from my being the last on this list and Windsor's status in the location of the province geographically. I start from this extraordinary premise that so far as the rights and duties as between a mortgagor and a mortgagee are concerned, the mortgage document has nothing, if anything, to say. The fact is that the most basic rights don't appear there. I defy you to find for me in the mortgage a concept of equity of redemption, the right to redeem, for that matter, the right to foreclose. The mortgage under the registry system in this province is simply a conveyance, a deed, from the mortgagor to the mortgagee with a proviso for defeasance, provided this mortgage to be void if I pay so-and-so. At common law, that condition was real. If there was a default, even by accident, on the date fixed for payment, the deed became absolute. There was no question of a forfeiture having been worked. The conveyance in the original mortgage declared that there was a conveyance to the mortgagee, there was an accidental default, title passed. Now, at common law, the debt still remained, so that the property was lost, and then there was an action on the covenant for the debt in addition. In the course of time, equity took the position that the sum and substance of a mortgage was a pledge, and therefore equity would intervene on its personal jurisdiction and say to the mortgagee, you must allow the mortgagor to redeem. So we had a concept, a creation, outside of the mortgage called the equity of redemption. And I've quoted one of my favorite quotes from Jarrett Timber talking about what a mortgage is. And he says, it's an instrument which perhaps lends itself to an imposition, for no one, I am sure, by the light of nature, ever understood an English mortgage of real estate. Now, we had in any event a new property, that is an equity of redemption. This was a property, as is pointed out, that can be conveyed, that can be entailed, and so on. The property is described in a quote at page M2, which is the last of the longer quotes that I'll read to you, in an 1892 decision as follows. Of course, one knows in general, if not in a critical way, what is an equity of redemption. It is a right not given by the terms of the agreement between the parties to it, but contrary to them, to have back securities given by a borrower to a lender. I suppose one might say by a debtor to a creditor on payment of principal and interest at a day after that appointed for payment, where, by the terms of the agreement between the parties, the securities were to be the absolute property of the creditor. This is now a legal right in the debtor. Whether it would not have been better to have held people to their bargains and taught them by experience not to make unwise ones, rather than relieve them when they have done so, may be doubtful. We should have been spared the double condition of things, legal rights and equitable rights, and a system of documents which do not mean what they say. But the piety of love of fees of those who administered equity has thought otherwise, and probably to undo this would be more costly and troublesome than to continue it. So you had equity on a proper case, fraud, hardship, and so on, accidental default, intervening sporadically. The sporadic intervention became customary and now has crystallized into the automatic 6 months that anybody who has the $2 to put in a notice DOR will, under the rules, get as a matter of right. So that is the property of the mortgagor. The mortgagee was then in this position. The mortgage is in default. The condition is absolute. I own the land. The mortgagor has walked in and broken the forfeiture. Still in default, but he's broken the forfeiture. And now where am I? So the mortgagee came into equity to ask the court to stop the new right it had given to the mortgagor, the foreclosure. So the foreclosure is a right given by equity to terminate a right given by equity to the mortgagor. It's a second level of power outside of the mortgage. Now, those are the doctrines we're dealing with. And I think that will explain some of the, like landlord and tenant law, the real property background of these remedies, which takes us into unwritten and unspoken premises. Now, the subject matter of my paper is defenses. And I hope to spend a bit of time on material not in the paper because the same kind of idiot who can write this kind of thing can read it. But just to go quickly through defenses. We've had reference to Section 22 of the Mortgages Act. Section 22 being the right on payment into court of $100 to get a stay. Let me introduce you to the first of what I call the gotcha cases. Gotcha is spelled G-O-T-C-H-Y-A, gotcha. This is DeCrypt and Beach at page M4. Straightforward writ for foreclosure, possession and payment, normal everyday writ, issued and served. Mortgagor gets the writ, calls up his lawyer and says, I want to make this good. Take care of it for me. Series of phone calls between the two law firms, and they can never reach each other on the phone. One of them goes on vacation, the 15 days goes by, default judgment. All right. The mortgagor brings an application to set aside the default judgment. He's unsuccessful. He tenders, brings another application to set aside the default judgment. He's unsuccessful again. He appeals to the divisional court. Now, without going through the detail, the court points out you didn't pay in the $100. In one of your affidavits, you admitted that this terrible mortgagee, in showing how tough the mortgagee was, had actually attorned rents. Therefore, the mortgagee is in possession. You didn't pay in the $100. There is default judgment. Gotcha. Over. Maltmans, where are you now? I just point out you must actually tender the money, pay the $100. If you do those things as a matter of right, you can redeem. The second on the list of defenses is an outstanding demand under the Mortgages Act, Section 40. Remember, Section 40 says where there's demand for payment, such as in a notice of sale, you can't take any steps during that period. So if you can find the writ was issued inside of a notice period, and I extend that even to a demand letter, then you might find the writ to be defective. Thirdly, the provisions of Section 21 of the Mortgages Act. You have the right now, by a properly drawn letter, to demand a proper statement. If you don't get an adequate answer within 15 days, then the remedies stop running. If you've got a mortgagee who is an assignee, and he didn't get a proper statement of account from his assignor or from you, the mortgagor, there's no estoppel, then he may not be able to come up with a proper accounting, and you can stop him under Section 21. I'd like to deal with two areas now not in the paper, and these are recent cases. The first of them is the question of illegality. The case to which I'm referring is Central, not in the materials, Central and Eastern Trust against Irving Oil. 12, Real Property Reports, page 67, decision of the Supreme Court of Canada. Irving Oil granted a substantial mortgage to secure what turned out to be a transaction for a group who were buying shares in Irving Oil. The Nova Scotia Companies Act provides, it shall not be lawful, there's the word lawful, for a company to give, whether directly or indirectly, and whether by means of a loan, guarantee, provision, or security, or otherwise, any financial assistance for the purpose of or in connection with a purchase made by any person of shares in the company. The trial judge held that this was a valid security in that the money was granted to the company for corporate purposes, and he wasn't going to trace what happened. The Court of Appeal said that they were dividing the mortgage into two classes. Part of the money actually was traced through and paid off corporate responsibilities. That was good. The other part of the mortgage was used to purchase shares by this group. That was void. The mortgage was partially good and partially void. The Supreme Court of Canada, in a unanimous decision, which does not cite one single case, says the mortgage is totally void. Students of jurisprudence will readily recognize that this is a case which bases itself on the slender distinction between the concept of unlawful and the concept of unlegal. Unlawful, as we all know, means contrary to law, while illegal means a large, sick bird. If anybody else has a better explanation of the case, I'd like to hear it afterwards. I now want to deal with two cases on this vexing problem of the obligation of the mortgagee who has agreed to advance money to advance the money, a contract defense. And the first of them, Reid, R-E-I-D, against Garnett B. Hallwell, H-A-L-L-O-W-E-L-L, in 1978, 10 RPR 308, a decision of Master Stambler. This was an action for foreclosure. There was an affidavit of merits filed which alleged that the mortgagee had not advanced the money he covenanted to advance. The clause in the mortgage was one which I suspect is standard in just about any printed form you'd care to find. It's a mortgagee discretion clause. The mortgagor agrees that neither the preparation, execution, nor registration of this indenture shall bind the mortgagee to advance the money hereby secured, nor the advance of part of the monies hereby secured bind the mortgagee to advance any unadvanced portion. That was the clause. There was a motion for summary judgment in face of this affidavit of merits. Master Stambler granted summary judgment. Now, in doing that, in face of the affidavit of merits, he cited a decision of Mr. Justice Laskin when he was in the Court of Appeal in Frankel and Godin, which says that a mortgagor cannot ordinarily compel the advance of money promised, and so on, leaves open the possibility of extraordinary circumstances. He says in the ordinary case, you cannot compel the advance of monies. Master Stambler then goes on to deal with an unreported case that neither counsel gave him, but that he found in his own research, where the divisional court said, "We are not at all certain that the law is settled in Ontario that a mortgagee that has made a commitment to advance funds in a certain amount, even in the light of the clauses referred to in the mortgage, can capriciously and to serve its own purposes refuse to advance the full amount of the mortgage." So he goes on to point out that there can be exceptions. He then, rather gently, I thought, points out that the affidavit of merits was pretty weak. The affidavit of merits says, the plaintiffs did not advance monies pursuant to the agreement of the plaintiff. The defendants say their defense is based on the non-advancement of committed mortgage monies. No other facts and circumstances are set out as required by Rule 42, and it is impossible to ascertain what agreement there was by the plaintiff to advance the money. So he goes on to educate the solicitor who drew the affidavit of merits as to what ought to have been in it, and gives summary judgment against him for the full amount advanced. The second case, and it's one that I like a lot more, is called Grouse Nest Resorts and First National Mortgage. It's at 1 RPR 246, a decision of the British Columbia Court of Appeal. Here we had a mortgage for $1.25 million. The mortgage was granted to finance a land subdivision, to the servicing. The mortgagee advanced $120,000. The mortgagor did some more work and made an application for a further $175,000. The mortgage manager went out and inspected, agreed that the money should be advanced, and requisitioned it from his head office. The head office refused, in effect overruling their local manager. There was an action for damages for refusal to advance. The mortgage had the standard discretion clause. The trial judge found a duty to advance and assessed damages at the round sum of $586,266.82 without giving reasons. The Court of Appeal made the following findings. Number one, the parole evidence rule applies and you can't use an agreement outside the mortgage to justify the advance. Number two, the doctrine of merger applies. Any discussions between the parties was merged in the delivery of that mortgage. Read the mortgage, that's the definitive document. Next, there was no covenant to advance. The only duty was to determine bona fide whether there should be an advance and then to advance in accordance with that determination. However, there was a determination by the manager to advance. So the Court of Appeal finds 2-1 that having determined to advance, the mortgagee was in breach of contract by not advancing. That's the good news. The bad news is that the quantum of damages for failure to advance is the difference between the mortgage rate and what the person has to pay when they go out in the market to get it. Unfortunately, at trial, the plaintiff didn't lead that kind of evidence, so the quantum of damages was reduced from the round sum of $586,266.82 to the rounder sum of $1. Plaintiff won. Don't put it down, he won. The suggestion here has to be that if we're in a development type of mortgage, there never is, in the case of default, the mechanics liens are flying. It's a $10 million project, $500,000 advanced, $3 million of work done, stop advancing, the job shuts down, the liens are flying. There isn't another lender ready to lend the money. There isn't a comparative rate. Either you're going to get $1, or you had better have, I would suggest, an agreement, a loan agreement that doesn't merge on closing, that has objective standard for advances on engineers or architect certificates. Otherwise, you're going to get the $1, if you're lucky. Now, turning to the power of sale. Just as the right of foreclosure and the remedy of foreclosure is rooted in old law, the concept of power of sale is fresh. The power of sale is either statutory or it's contractual, but in any event, it's not terribly old. And the cases that you're going to be reading are modern cases. We've already had suggestions that you might want to take a very careful look at the notice itself to find that it was signed in the wrong way, not signed, so on. Defects in the notice, and there are some pages on it. There may have been a failure to serve everybody or to serve them in enough time. Those are always possibilities. The area I'd like to take a couple of minutes in is the concept of a notice of sale issued while there is a power of sale, or whether there's a foreclosure proceeding. There have been cases where a person gets bogged down in a foreclosure. He's just sick of it. There are affidavits of merits, there are discoveries, there are motions, and one day he says, the heck with it, for the price of a registered letter, I can, in 35 days, have this land. And he sends out his notice of sale. And there are cases that have said that having resorted to the Queen's justice, the mortgagee cannot now resort to his own. Either he goes with the courts or he goes on his own. You have to obtain leave to discontinue the mortgage procedure before going into a power of sale. My all-time favorite gotcha case on this is Greening Holdings Limited and Schnell at page 12, which is a beauty. Mortgagee issues a writ for foreclosure. He sits on it for 6 months, does nothing. Then, because he's suddenly in a hurry to get it served, he calls the other solicitor and says, look, rather than serve your client, would you accept service? The other solicitor calls him back and says, yes, I will. The next day, the mortgagee says, forget about the phone call from yesterday. I'm not going to proceed with this action. I'm going by power of sale. There is a race down to the courthouse, and 5 minutes before the mortgagee files his notice of discontinuance, the mortgagor files an appearance gratis and a notice DOR gratis and gets an automatic 6 months. We have an unserved writ, and Judge Hansberger said, if you hear about a writ against you, you needn't do anything about it, but you have the right to file an appearance gratis. Having filed an appearance gratis, the action is going, you have the right to file a DOR. Having filed a DOR, you have 6 months. So here we have an accidental 6-month extension. Now, in terms of defending power of sale proceedings, let's keep in mind there isn't an action. When you go down to the courthouse to read the file, there isn't a file. You've got this kooky form that you've received from the postman, and that's all you've got. So the defenses you will be asserting, even though you're asserting similar defenses to, let's say, a mortgage action, failure to advance, illegality, whatever other creative situation you can think of, those defenses have to be asserted in an injunction proceeding. You are now the plaintiff seeking an injunction. The shoe is entirely on the other foot. You've got the burden of proving balance of convenience. You've got the burden of undertaking as to damages, and so on. So you apply for an injunction. And let me say now that you had better have a strong affidavit. The cases are replete with instances of general statements of undervalue. That property of mine, on which I haven't seen fit to pay 40 cents over the last 9 years, is worth millions. And there are people just waiting to buy it for cash. They've never approached me in the last 14 years, but they're there, and this guy is giving it away. Those affidavits just don't work. If I can refer you to one recent case, on that kind of situation, Hotel California Holdings and Grossman, 11, not in the material, 11 RPR at 66, a substantial mortgage with just a vague allegation that this property is worth $2 million, not substantiated. Application for an injunction, and the plaintiff got what I'm going to suggest to you is the best order any plaintiff will ever get. He was able to establish that there had been some negotiating meetings for an extension. That was proved on examinations. Based on that, he got an order that upon payment of all arrears and upon continual payment monthly of interest, there would be an interlocutory injunction until trial with the injunction to automatically dissolve on default. My suggestion to you is that is as far as you can go, and you better be ready to tender all arrears and to offer the court monthly interest as a condition. You are certainly not going to get any kind of relief short of payment. Let me conclude today with an announcement to parallel the announcement that we started with a dozen speakers ago, the announcement of the Ontario Law Reform Commission project on mortgages. I've started my own project on creative legal writing in Ontario. I'm inviting everybody to send to me copies of affidavits of merits which you receive on foreclosure actions. And I'm compiling them into a book. There's a working title now called The Check is in the Mail.
Thank you very much, Arthur. With the completion of the delivery of a very excellently prepared and entertaining paper, this concludes our program. Thank you for attending.